Hello, welcome in. This explainer is designed for first-year law office study students and curious minds. And hey, since this was created by students for students, please hit that like and subscribe button right now. It really helps us out. So, contract law. It's basically the invisible scaffolding of our entire economy, right? It governs absolutely everything, from buying your morning cup of coffee to pulling off multi-billion-dollar corporate mergers. But before any of that magic can happen, a contract actually has to be born. And today, we're going to explore exactly how that happens.
To really hook us into this wild world of contracts, let's look at the totally bizarre 1892 Carlill versus Carbolic smokeball case. Picture this. It's a deadly flu pandemic, and a manufacturer takes out an ad making a wild promise. They said they would pay £100, which, by the way, was a massive sum back then, to literally anyone who used their rubber smokeball flu remedy and still got sick. They even deposited £1,000 in the Alliance Bank just to show everyone how serious they were. Well, spoiler alert, a Mrs. Carlill used it, and yep, she still got the flu. The company tried to backpedal, claiming it was just marketing fluff, not a real legal offer. But the courts, they totally disagreed. That accidental promise created binding law that we are literally still studying today.
Okay, so let's dive into our agenda. This actually mirrors the IRAC analytical framework you're going to need for those law school exams. We're going to systematically walk through the legal life cycle of an offer. We'll start with the anatomy of an offer, look at bilateral versus unilateral contracts, figure out what an invitation to treat is, learn how to terminate an offer, and then wrap it all up with the famous mirror image rule. Let's get to it.
Starting off with Section 1, Anatomy of an Offer.
Right, so before we can even talk about accepting a deal, we need to dissect what actually makes something a legally effective offer, rather than just, shooting the breeze or preliminary negotiations. The absolutely crucial point here is that courts use the objective theory of contracts. Honestly, they do not care about your secret internal thoughts. They only care about what a reasonable person would think your outward words and actions meant. A famous example of this, the Lucy versus Zehmer case. You've got two guys drinking at a restaurant, and Zehmer literally writes up a contract on the back of a restaurant check to sell his $50,000 farm to Lucy. Later on, Zehmer tries to say, hey, it was just a drunken joke, I didn't actually mean to sell. But the court looked at his outward actions, writing it all out, detailing the property, signing the thing, and said, nope, a reasonable person would think you were serious. Bam, binding offer.
Now you've got to watch out for a stark contrast between two different sets of rules. Here is a major bar exam tip for you. If you are dealing with real estate or services, you are firmly in common law territory. That means strict, definite terms. You absolutely must have the parties, the subject, the price, and the quantity spelled out. But if you're dealing with the sale of goods, you shift over to the Uniform Commercial Code, or UCC Article 2. And the UCC is super flexible. It loves what we call gap fillers. As long as there's a clear intent to contract and a set quantity of goods, the court can magically step in and fill in a missing price term with a reasonable price. Pretty handy, right?
Moving right along to Section 2, Bilateral versus Unilateral Contracts.
All right, now that we know what an offer actually looks like, how do we classify them? And how do we accept them? Well, the vast majority of everyday business deals are bilateral contracts. That's just a promise exchanged for a mutual promise. You promise to buy the house, the seller promises to hand over the deed. Both of you are bound immediately the second you agree. On the flip side, we have unilateral contracts. This is a promise exchanged for a specific act. Think of a lost dog reward flyer. You aren't promising to go out and find the dog, right? But if you actually perform the act of finding the dog, then the offerer is legally bound to pay you.
So how does this play out in the real world? Let's talk about the part performance rule. Historically, an offerer could technically revoke a unilateral offer right up until the exact second you completely finish the task. Imagine painting 99% of a house and suddenly having the offer pulled. Totally unfair. To fix that injustice, the modern rule completely protects the offeree. Once you start searching for that lost dog, or start painting that house, the unilateral offer transforms into an irrevocable option contract. The offerer literally cannot suddenly revoke their offer while you are actively doing the work.
Next up, Section 3, Invitations to Treat.
Okay, let's do a quick Socratic question just to test your legal instincts. Is a store display with a price tag on it legally considered an offer? Surprisingly, no, it's not. Standard store displays, advertisements, even auctions, they are merely what we call invitations to treat. Essentially, the seller is just putting it out there saying, hey, I invite you to make me an offer for this item at this price. When you take that item up to the cash register, you are the one making the offer, and the store accepts it by taking your money. This is a super crucial distinction, mostly because it protects sellers from getting sued for breach of contract if they accidentally run out of stock after running a newspaper ad.
But of course, this is the law, so there are always exceptions. Take the famous 1957 Lefkowitz case. The great Minneapolis surplus store published an ad that said, Saturday, 9 a.m. sharp, 3 brand new fur coats, worth to $100, first come, first served, $1 each. Well, Mr. Lefkowitz was first in line, but the store refused to sell him the coat, claiming they had a house rule that the offer was strictly for women. The court actually sided with Mr. Lefkowitz because that advertisement was so clear, so definite, so explicit, and left literally nothing open for negotiation, it actually transformed from a mere invitation to treat into a fully legally binding offer.
All right, on to Section 4, terminating the offer.
So we've successfully birthed an offer, and we've classified it. But how does an offer die before it can be formally accepted? We can systematically cross off the life of an offer through 4 specific steps. Step 1. The offerer simply takes it back. That's a revocation. Step 2. The offeree says, no thanks, or maybe they suggest a new price, which actually acts as a rejection and a brand new counteroffer. Step 3 is just a lapse of time. If the offer says good until Friday, well, it dies on Saturday. And finally, Step 4. External legal events intervene, which we call termination by operation of law.
What's really fascinating here is how the law just steps in automatically behind the scenes. For instance, if an offerer unfortunately dies or becomes legally incapacitated before the offer is accepted, the offer dies right along with them. Or let's say the subject matter of the contract is suddenly destroyed. Imagine you offer to sell me your car, but before I can accept, lightning strikes it and it burns to a crisp. In that case, the power of acceptance is immediately terminated by operation of law.
But wait a second. Offerers can't always just take their offers back. Here's another highly tested bar tip for you. You need to know your irrevocable offers cold. You absolutely must understand the difference between common law option contracts, where you actually have to pay something, called consideration, just to keep an offer open for a specific amount of time, and UCC firm offers. Under the UCC, if a merchant makes an offer to buy or sell goods in a signed writing, and it gives assurance it'll be held open, it is irrevocable for up to 3 months. And the kicker? No consideration is needed at all.
And finally, we arrive at Section 5, the mirror image rule.
This brings us to the ultimate realization of an offer, assuming it hasn't been terminated, of course. Let's dive into this foundational common law principle. To form a valid contract under traditional common law, your acceptance must be a perfect, absolute mirror image of the original offer. You can't add conditions, you can't change the timeline, and you definitely can't tweak the price.
Because if you change even the slightest detail, you haven't actually accepted the deal. Instead, the law says you have legally rejected the original offer entirely, and you've just created a brand new counteroffer. Think about it. If someone offers to sell you their laptop for $1,000, and you say, I accept, but I'll pay $950, that original $1,000 offer is dead and gone forever.
Now, as we wrap things up today, I really want you to think about how these traditional rules clash with our modern digital reality. How does e-commerce, like just clicking a simple Buy Now button on a website, complicate these strict 19th century rules of offer and acceptance? When you blindly check a box for terms and conditions that you definitely didn't read, are we really still following the mirror image rule? I'll leave you with that provocative thought for your next study session. And hey, since this explainer was created by students, for students, please don't forget to like and subscribe so we can keep making these for you. Thanks so much for hanging out with us, and happy studying.